Today, on May 4th, 2026, the people of West Bengal delivered their verdict. But this story did not begin today. It began years ago, in the silence of a Prime Minister who had every legal tool at his disposal and chose not to use them. This is not a story about politics. This is a story about patience, about a man who believed, against all pressure, that democracy must be allowed to answer what emergency cannot. Article 356 of the Indian Constitution gives the President of India, acting on the advice of the Prime Minister, the power to dismiss a state government if, and I quote, "a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of the Constitution." In the last 5 years, West Bengal gave any sitting Prime Minister not one, not two, but multiple moments that would have passed that legal threshold, on paper. And Narendra Modi did not use it. Not once. Let us be clear about what that restraint meant, because to understand the decision he made, you must first understand what was happening on the ground. May 2021. Trinamool Congress wins West Bengal by a landslide. Within days, violence sweeps across the state. BJP workers are killed, their homes burned, their families driven out. Of the 1,934 complaints filed with authorities, nearly 40% went without an FIR being registered at all. The NHRC committee, in its own words, found that criminals acting with state patronage and support had systematically planned and executed the violence across the state. This is the moment many expected the centre to act. The governor raised it, the courts raised it, the NHRC raised it. But Article 356 was not invoked. August 9th, 2024. A young doctor, a woman serving her country in a government hospital, is raped and murdered inside R.G. Kar Medical College in Calcutta. What follows is not just a crime, it is a collapse. The crime scene is not sealed. Opposition leaders, citing CCTV footage, alleged that dozens of people had walked through the crime scene before it was even sealed by police. The former principal of the college and a senior police officer are later arrested for tampering with evidence. The victim's own mother would say publicly, "The Chief Minister cannot disown the failure of the Calcutta police and the administration." The Calcutta High Court transfers the case to the CBI, saying the state police investigation did not inspire confidence. The Supreme Court takes suo motu cognizance. Doctors strike for 42 days. India protests. And still, no Article 356. Sandeshkhali, 2024. Women from this small area come forward with allegations of land grabbing and sexual exploitation by a TMC strongman, Sheikh Shah Jahan. He is a local power broker. He goes missing. For weeks. And the state police cannot find him. He is eventually arrested, not because the state acted, but because the courts forced the issue. It takes judiciary intervention to do what basic law enforcement should have done on day one. Around the same time, a massive corruption scandal unfolds in Bengal's education system. Billions in bribes had been taken for government schoolteacher appointments. The Calcutta High Court cancels thousands of appointments, real teachers who had done nothing wrong, losing their livelihoods overnight. The former education minister is arrested by the CBI, and the trail leads directly into the ruling party. January 8th, 2026. The Enforcement Directorate is conducting a lawful raid on the offices of IPAC, a political consultancy firm, in connection with a documented 2,700 crore rupee coal smuggling case. Then something happens that has no precedent in independent India's history. The Chief Minister of West Bengal personally arrives at the raid site with over 100 police officers. And in full view of the Enforcement Directorate's investigating team, laptops, documents, and electronic devices, evidence in a money laundering probe, are removed from the premises. The state then files FIRs against the ED officers who were conducting the raid. The Supreme Court of India, hearing the matter weeks later, uses words that would have chilled any constitutional scholar. A judge asks directly, "Are you arguing breakdown of constitutional machinery in West Bengal?" The Solicitor General of India tells the court, "There is a complete and total failure of rule of law in the state." And still, the Prime Minister did not invoke Article 356. April 1st, 2026. 7 judicial officers, appointed by the Supreme Court itself to oversee the revision of Bengal's electoral rolls, are surrounded by a mob in Malda. They are kept without food for more than 7 hours, in a government office, unable to leave. The Supreme Court's response is unprecedented. It calls it a complete failure of state administration. It describes West Bengal as the most polarized state in India. It orders central forces deployed to protect future judicial proceedings. When the judiciary itself has to ask for protection to function within a state, you are looking at something serious. And still, the answer chosen was not emergency. It was election. Here is the question this video is really asking. Why? When institutions were failing, when the courts were alarmed, when a sitting chief minister had been accused, on record in the Supreme Court, of obstructing a federal investigation, why did the Prime Minister of India not act under Article 356? The easy answer is political calculation. But there is another answer, and it is a more important one. Emergency is a blunt instrument. Article 356 has a dark history in India. It was used 91 times between 1950 and 1994. It was used against elected governments for political convenience. The Supreme Court, in the landmark Banerjee judgment of 1994, placed strict guardrails around it, ruling that the floor of the Assembly, not the office of the President, is where governments must be tested. Modi understood something that history teaches us the hard way. Emergency powers, once normalized, do not stay with one leader. A Prime Minister who dismisses a state government today becomes the precedent for the next Prime Minister to dismiss one tomorrow, perhaps for far less. Emergency answers a crisis, but it does not resolve one. It suspends the problem. It does not solve it. The people of Bengal had not yet spoken, and their voice, in a democracy, is not just important. It is the only legitimate answer to the question of who should govern them. So instead of emergency, the centre chose something harder. It chose to work through institutions, the courts, the Election Commission, the deployment of central forces, to ensure that when Bengal finally voted, it voted freely. 2.4 lakh Central Armed Police Force personnel were deployed across West Bengal for this election, the largest such deployment in the history of Indian democracy. Not to govern, not to suspend, but to protect the right of every Bengali citizen to walk to a polling booth without fear. On May 4th, 2026, West Bengal counted its votes. And in that count, in those millions of individual choices made by ordinary people in polling booths guarded by central forces, the democratic answer arrived. This is not a moment for triumphalism. A government falling is never a a celebration. It is a correction, and every correction carries with it the weight of what made it necessary. Think of the doctors who struck for 42 days, the women of Sandeshkhali who came forward at great personal risk, the families displaced after 2021, the judicial officers who sat in a government office in Malda without food for 7 hours, waiting for someone to protect them. This verdict is, in some part, for them. There is a version of this story where emergency was declared in 2021, or in 2024, or in January 2026, when a chief minister walked into a federal raid and took the evidence. Each of those moments had legal arguments that could have been made. But India has already lived through an emergency. In 1975, Indira Gandhi declared one, and the country spent decades recovering from what that decision normalized. A prime minister who refuses to use emergency powers even when provoked is not showing weakness. He is showing restraint, the hardest kind, because it requires trusting a process that may take years to deliver what emergency could have delivered in a day. Democracy is slow. It is imperfect. It is sometimes agonizing to watch. But it is the only system in which the answer, when it finally comes, belongs to the people. Not to a governor's report, not to a president's proclamation, not to a decree issued from New Delhi. To the people. The patience of a democracy is measured not in how quickly it acts, but in how faithfully it waits for the people to speak.